Today we're filming in a hotel room in Salt Lake City. So here we go. On January 1st, 2024, after nearly a century of copyright protection, Mickey Mouse has officially entered the United States public domain. This means you can use Mickey Mouse in your own creative work, and you might even be able to copyright that work. Sorta. To figure out what is and isn't allowed, we need to do a little background on copyright and trademark law. So if you're a creative who's interested in using Mickey Mouse or one of the other figures in the public domain, or if you're just interested in strengthening your trademark and copyright skills, this video is for you. In this video, we're going to discuss Mickey Mouse, copyright and trademark law, what happens when a copyright expires but there's still a trademark, and the public domain. So who am I anyway? My name is Tiffany and I am an intellectual property and business attorney. I work with small businesses to help navigate the business side of your business without all the confusion and overwhelm. First, a quick disclaimer. I am an attorney, but I am not your attorney. The things I talk about in this video should not be construed as legal advice, and I always recommend speaking to an attorney who is licensed in your state. First off, the Mickey Mouse that we're going to be talking about in this video is the 1928 Steamboat Willie Mickey Mouse. And we're specifically talking about United States copyright law. Whether the Mickey Mouse from Steamboat Willie is still protected in other countries really depends on the specific country. In some countries, it is still protected by copyright, and in other countries, it is already in the public domain. What makes Mickey Mouse so important? There are a ton of other characters in the public domain, like Sherlock Holmes and Winnie the Pooh and Snow White. So why are we so concerned with Mickey Mouse specifically? Copyright law dates back to about 1790, and it's gone through a ton of different iterations in that time. Most notably, there's the Copyright Extension Act of 1976, which extended the copyright term to 75 years or the life of the author plus 50 years. And then there's the Copyright Term Extension Act, which is sometimes referred to as the Mickey Mouse Protection Act, and this extended the copyright term to the life of the author plus 70 years. And if you're wondering why it's called the Mickey Mouse Protection Act, that is because Disney was one of the main players that was lobbying to extend this copyright term, and that's because their copyright on Mickey Mouse was soon to retire. So because of its long history, the fact that Mickey Mouse is finally in the public domain is a pretty big deal. Which Mickey Mouse are we talking about here? So don't go worrying about Disney just yet. They still own the copyrights to all the other versions of Mickey Mouse. For example, The Sorcerer's Apprentice from Fantasia, that Mickey Mouse is still under copyright protection. Here's a fun fact though. We're talking specifically about the Steamboat Willie Mickey Mouse from 1928. At the time, this film was considered a technological marvel, and that's because it's one of the first to have fully synchronized sound. Disney himself performed the dialogue, which is mostly unintelligible. It was initially set to enter the public domain in 1984, and then it was pushed to 2004, and then in 1998 it was pushed to 2024. There are also some that argue that this work should have gone directly into the public domain and was not entitled to copyright protection due to defects in the copyright notice back in 1928. But we know that officially, Steamboat Willie Mickey Mouse is in the public domain as of January 1st, 2024. So can you use this version of Mickey Mouse in your works? The short answer is yes. The longer answer is yes, but let's dive in. Copyright versus trademark law. Copyright and trademarks are different. Copyrights cover creative works, and it prevents others from using or adapting those works without permission. I made a whole video on copyright law, and I'll link it somewhere up here, and this goes into all the basics of copyright law. So basically a copyright law 101. You have the right to reproduce the work, prepare derivative works, distribute the work, and to display or perform the work publicly. These rights expire. The current rule is that works created on or after January 1st, 1978 are entitled to copyright protection for the life of the author plus 70 years after their death. Trademarks cover words, logos, and other signifiers that serve as brands identifying their products. The goal for trademark protection is to minimize consumer confusion in the marketplace. So for instance, Nike can put their swoosh symbol on some of their athletic apparel, and this lets people know that they are buying a Nike item, and it signifies that they're going to get the quality that they expect from a Nike item. Unlike copyright law, trademark protection does not expire. As long as it's still being used in commerce, it will still continue to be protected. The issue is that sometimes copyrights and trademarks overlap. Mickey Mouse can be protected under copyright law and trademark law. So under copyright law, you would have Mickey Mouse, the creative figure, the drawing, the creative work would be protected. And then under trademark law, Mickey Mouse as a logo can be protected. So like if you put Mickey Mouse on a backpack, that might lead someone to believe that that is an official Disney product. What happens when the copyright expires, but not the trademark? The Supreme Court has made it clear that you can't make a run around copyright law by using trademark law, because this would, quote, create a species of mutant copyright law that limits the public's federal right to copy and to use expired copyrights. In the case of Mickey Mouse, Disney still has trademark protection in Mickey Mouse the character and the words Mickey Mouse in relation to their products. So can you use the Steamboat Willie Mickey Mouse in your works if it's still under trademark protection? The test is whether or not people will be confused as to the source of the work. As long as no one thinks it's a Disney joint, you should be okay. Make sure you're not using this Mickey Mouse in a way that would mislead someone into thinking that it's a Disney product. Like if you use the Steamboat Willie logo at the beginning of an animation that you made, that really might look like it is a Disney production. So that is going to go against Disney's trademark protection. In fact, Disney still uses this logo at the beginning of some of their films. A good idea to avoid any potential consumer confusion is to have some sort of disclaimer that says it is made by you and not by Disney. Make it clear that your work is not made by Disney and is not sponsored by Disney. So now that the Steamboat Willie version of Mickey Mouse is in the public domain, let's talk a little bit about what is the public domain. Public domain refers to creative materials that are not protected by intellectual property laws, such as patents, trademarks, and copyrights. No individual person owns these works. They are owned by the public. That means you can use any of these works without permission. There are 4 common ways a work can end up in the public domain. The copyright has expired. This is what happened with Mickey. The copyright owner failed to follow the copyright rules for renewal. The copyright owner places the work in the public domain deliberately. This is called a dedication. Or the particular type of work isn't qualified for copyright protection. For expired copyrights, keep in mind that the copyright expiration date will actually be the end of the year in which that copyright expires. So for instance, if you have a copyright that is set to expire on June 15th, 2027, that means that work will actually expire on December 31st, 2027. Another thing to be aware of is for dedications or copyrights that are placed into the public domain deliberately, make sure there is an express authorization that this be in the public domain. So for instance, it should say something like, this work is dedicated to the public domain. If it doesn't say something like that, do not assume that it is free to use. Disney is actually a really great example of why the public domain is really important. They have prolifically taken from the public domain to create some of their most famous movies. For instance, Alice in Wonderland came from Lewis Carroll. Snow White came from the Brothers Grimm. The Hunchback of Notre Dame was from Victor Hugo. Sleeping Beauty and Cinderella are both from Charles Perrault. The Little Mermaid was taken from a Hans Christian Andersen work. And Aladdin came from the Book of 1001 Nights. So what should you take away from this video? 1, you can use the Steamboat Willie version of Mickey Mouse in your own creative works, but just be careful. Respect the trademark and make sure you are using the proper version of Mickey. 2, do like Disney and look to the public domain for inspiration. The public domain isn't a place where copyrights go to die, so make sure you're taking a look there and see if maybe you can't find some inspiration. So that's it for today. I hope you got a little bit more knowledge on copyright law, trademark law, and the public domain. If you have an idea for a video you want me to make or a topic you want to see discussed in a future video, please be sure to leave it down in the comments. And if you found this video helpful, please be sure to like and subscribe. I will see you soon and goodbye. There goes Sailor. Good girl.